hope that you're still on fire, despite that we might feel a bit sleepy, because this session supposedly become the hot debate, yeah, because talking about human rights is always involving not only the knowledge of the development of the legal itself, but also talking about the culture, the belief, yeah, which sometimes we're not always agree, yeah, because it involves biases, it involves knowledge that we bring up to our neighborhoods, yeah, and the country, yeah, and when talking about the region, yeah, it becomes more even complex, yeah, because some authors or some experts may have said that there might be no universal human rights, and especially within the region of Southeast Asia, and we know that ASEAN is keen to have a framework, or let's say a rule-based mechanism to uphold the so-called standardized human rights in the region, but up until now we are not yet established what the so-called ASEAN human rights. So in this case, we would like to hear a number of presentations from hopefully 4 presenters. Yeah. The first one, we're looking forward to hear from Carolina Lubis, Miss Carolina, which the title, the paper is The Tale of ASEAN Way and International Human Rights Law. And secondly, we have Dr. Phil Sengkrai. Yeah. He will be presenting on ASEAN Human Rights Law as a concept. And the third, we have Nivedita Chowdhury and Shruti Chaturvedi will be with us online. Yeah. They will talking about upholding the right to profess and practice the religion of choice, comparative study of constitutional courts in Southeast Asia. And lastly, we will hopefully have Professor Balakista Reddy, which is also joining online. He will be speaking on the re-evaluating in international order in the wake of COVIDization. It's another term, COVIDization, insights from Southeast Asia. Okay, without further ado, I would like to introduce the first speaker, Miss Carolina Lubis. Currently, she is the candidate PhD in her first year in the Faculty of Law and Criminology, Catholic University of Leuven. She's part of the Leuven Global Governance Studies and the Institute of International Law at the institution. This abstract or this paper is her original paper and is intended to be discussed with the panel of early career students, but you're here now, so this is your panel. Okay. All right, Carolina, maybe 15 minutes, yeah, for the presentation. Time's yours.
Okay. Should I?
Are we good? Okay, send me a message. Okay.
Thank you, our dear chairman. Thank you and good afternoon, everyone. Goedemiddag allemaal. Ik spreek een beetje Nederlands.
Okay.
A little bit slow. Goedemiddag. Today I'm going to present a story about ASEAN Way and International Human Rights Law as shown on the slide, but please bear in mind that all events and episodes in my presentations will happen in the world who use International Bill of Human Rights as the standard. An International Bill of Rights consists of Universal Declaration of Human Rights and 2 fundamental covenants, which I forgot the full title of the covenants. So kindly check for yourself. Don't be like me who never memorized the name of international covenants. Okay? As we commonly know, ASEAN is an international organization based in Southeast Asia, and Southeast Asia is part of a larger Asia, and Asia is a region whose commitment to human rights promotion and protection is consistently reviewed and questioned. This is also true for Southeast Asia and also true for ASEAN in particular, due to its stubbornness to maintain the ASEAN way. I call it stubborn because we really don't want to change anything of ASEAN way. Okay? So therefore, with that being said, my story today will be about acknowledging the critics of ASEAN way and exposing its potential growth by briefly present the background of ASEAN way establishments, its evolution in the organizations, and eventually discuss the ASEAN way in current human rights mechanism in ASEAN. And of course, in the end of this discussion, a recommendation will be given. Now let us start with ASEAN way first. What is ASEAN way? Two core principles: the non-interference and consensus. That is ASEAN way is non-interference principles and consensus. Sorry about that. The non-interference defines the relationship between the member states where they respect each other's sovereignty and refrain from intervening in internal affairs, while consultation and consensus pertain to the organization decision-making mechanisms. So that is ASEAN way. There were myriad events underlies these principles. So they did not just come out of nowhere. Non-interference should be understood in the context of post-independence and Cold War situations. Let's go back a little far away in the ancient era. After gaining independence, unfortunately, many states in Southeast Asia were involved in disputes over territories. Take Malaysia with Filipina over North Borneo, and then there is Vietnam and Cambodia over border disputes. That's two things for instance, that will depict or give description about the dispute in Southeast Asia. And these kind of disputes were exhausting for newly independent states that actually needed to focus to build their economy aspect. The Cold War also a contributing factor because it heightened the tension in the region. We know Southeast Asian countries were caught in the middle of major power rivalries, where superpowers, clashes, and competed to spread influences in Southeast Asia. So these circumstances, the post-independence situation and the Cold War situations, deeply intertwined and inevitably fostering tension and suspicion between the countries in the region. So, given the situations, the government's leaders understood that something needed to be done because what they required was cooperation, not suspicions toward each other. So to mitigate the growing tension and suspicion, they created a forum. But this forum, this new created forum, should be a forum where the respect for sovereignty is paramount, okay? And then internal affairs were regarded as entirely national matters. So that's the requirement for this new forum. Hence, the principle of non-interference. That's the reason why this principle become the integral part to all ASEAN activities, including those related to human rights promotion and protection. So the spirit of non-interference and consensus decision-making is also enshrined in the Bangkok Declaration, if any of you heard about Bangkok Declaration. And the spirit aligns closely with the principle of sovereignty, non-confrontation, and prioritizing diplomacy. So that's the intertwined principle in ASEAN Way and in Bangkok Declaration. Unfortunately, although the ASEAN Way was intended to support human rights initiative, the ASEAN Way is often considered a hindrance to human rights protection because it is state-centric. It is too state-centric. Based on sovereignty principle, the states hold unshakable maximum power, right? Based on the principle sovereignty, the state holds unshakable maximum power. Furthermore, if there is an alleged human rights violations in its territory, a state will declare it as an internal affair. Subsequently, based on the non-interference principles, other states must refrain from doing something that could be claimed as interference. In line with non-confrontation and prioritizing diplomacy, rather than opting for a judicial body to address human rights issues, ASEAN member states tend to address human rights issues through dialogue, in spirit of consultation and consensus. This is precisely the subject of critics' arguments against and proponents' defenses of the ASEAN Way. While critics argue that the ASEAN Way hampers human rights initiative, the proponents believe it has the potential to protect and promote and protect human rights. So, is it an obstacle or an opportunity for human rights? That depends on how we approach this ASEAN Way. The tension over human rights also appear and shape the process of modernizing ASEAN. Let me talk a little bit about modernizing ASEAN because historically speaking, there was a time when ASEAN as an association reached an understanding that it needed to remain relevant to the changing realities surrounding it. And ASEAN had been operating without a sufficient legal framework. So during Bangkok Declaration era 1967, association is not an international organization. ASEAN is merely an association, a political forum. So this awareness led the government leaders to issue the Kuala Lumpur Declaration on the establishment of the ASEAN Charter, which led to the formation of the Eminent Person Group and High-Level Task Force. So these two bodies was given task to create ASEAN Charter. So now, in our contemporary era, ASEAN already has its ASEAN Charter. And ASEAN Charter is established in 2007. So ASEAN is quite young. As an international organization with a founding charter, ASEAN is quite an age, 17 years old, I guess. Yeah, 2007, 17 years old. But during the Eminent Person Group and High-Level Task Force do their tasks, do their job, there is also a heated tension, heated debate about human rights initiative. Okay, the Eminent Person Group, as a group of experts with mandate to think boldly and visionarily, proposed the idea of human rights mechanism. So the idea about human rights body in ASEAN come first from the Eminent Person Group, and they are a group of experts who work independently. Unlike the Eminent Person Group, the High-Level Task Force is intergovernmental forum. So the member of High-Level Task Force work based on the state assignment, state official assignment. And the state who assigned the High-Level Task Forces member is states who mainly uphold the ASEAN Way, non-interference and the and the consensus to make decision. So this is why it is understandable that human rights become the most contentious topic during the drafting of the ASEAN Charter. As testified by some members through their writing, the tension reached reached the level that almost destroyed all the drafting operations. That's how sensitive human rights in Southeast Asia. That's how sensitive the topic is in Southeast Asia. Okay? So, but the most interesting part, at least in my opinion, was how an agreement was finally reached among the heated tension between the high-level task forces members. Because they were representative states, the member of the force had to consult with their foreign minister about this heated issue. Surprisingly, the foreign minister reached a consensus that ASEAN would establish a human rights body and designate the body as one important organ within ASEAN. So please remember, foreign minister is a political word, right? So it turns out the political tension in Southeast Asian countries can be balanced, can be overcome through the consensus principle. So in a way, the ASEAN way looks like will make everything slow, but on the other hand, the ASEAN way itself can be used to improve the organization. As a result, as we commonly know, ASEAN adopted its charter in 2007, and this human rights body is articulated in Article 14 of the charter. The name is ASEAN Intergovernmental Commission on Human Rights. And the establishment of this human rights body is an achievement, and I'm being told that this human rights body is the first of its kind in ASEAN region. So, an establishment is an achievement, but it's one story, and implementation is another story. Okay? Because the ASEAN human rights mechanism is set as intergovernmental commissions, their work, their initiative, their competencies is limited to the ASEAN way itself. So they are not an enforcement body. The ASEAN human rights body is a consultative body who give recommendations. And their work and their document or whatever decision they have made, whatever documents they will produce, is considered as non-adjudicatory and non-binding in nature. This non-adjudicatory and non-binding nature appears especially weak if we compare it to fellow regional organizations like European Union, African Union, and something in America, Organization of America. Sorry, I forgot the name. Yeah.
Organization of American States.
Yeah, that one. The three regional organizations were equipped with human rights court and binding treaties on human rights. So I can understand why critics so disappointed in ASEAN human rights body. But the ASEAN human rights mechanism is not completely without benefits. Three reasons. There are three reasons why I said it's not completely without benefits. Three reasons. First, ASEAN human rights mechanism is good in producing useful soft law. It's good in producing useful soft law because now we have ASEAN human rights declarations in 2012, if I'm not wrong. In 2012, ASEAN human rights declaration. No matter how toothless it may seem to critics, ASEAN human rights declarations is set a common language for human rights in the region. The second reason is ASEAN human rights mechanisms through ASEAN Committee, Human Rights Committee and ASEAN Committee on Women and Children, they bridging the ASEAN member states to the level of international human rights monitoring framework. How do they do that? Because these two bodies periodically help member states to prepare their report to Universal Periodic Review. For those of you who never heard about Universal Periodic Review, it was part of human rights monitoring and evaluation within United Nations. So these two bodies help the ASEAN member states to prepare their report. So eventually, ASEAN member states will be in the level of international human rights monitoring. The last reason is ASEAN human rights mechanisms engaging intensively with civil society organizations and also the national human rights institutions in ASEAN, because 6 of 10 ASEAN member states already established national human rights institutions in their country, in their territory. So this kind of activities will help ASEAN member states to improve their national regulation of human rights law. Yes, ASEAN human rights body do not have the enforcement competency, but they have the competence to help national human rights regulation to become better. So I think we should give credit to them. So 2 more minutes. Yeah. Okay then. That's my argument to say that human rights mechanism in ASEAN is not completely without benefit. So in a sense, the ASEAN way is slowly adapting. I have to admit the progress is slow, but being slow does not mean there is no progress at all. Thank you, and I will stop myself. Thank you for listening.
Thank you very much. Okay, having the introduction, so-called, how ASEAN is established and then developed, especially in the area of human rights. Now we're going to continue the advancement of ASEAN human rights in terms of the legal development, in which Dr. Phil will present his paper on, is it possible, that ASEAN have its own human rights law. He is a PhD in international law, summa cum laude, from the Graduate Institute of International and Development Studies in Switzerland. And he's also have a diploma in human rights law by European University Institute, Italy. And he is currently a lecturer at Thammasat University, where he teaches public international law, international human rights law, and constitutional right. His previous research topics include Thailand's ratification of the optional protocol to the Convention on the Rights of Persons with Disabilities, human rights situation in Myanmar, and obligation erga omnes partes, and the standing before the International Court of Justice. Dr. Phil, stage yours. You want to sit here? Okay.
Is it possible?
Yeah, sure.
Okay, sure.
You want me to help with the...
No, there's no slide.
Oh, no slide. Okay. No worries.
Thank you very much. Thank you for the very kind introduction. And let me first thank the organizers of the conference. As Jas Pagalangan said yesterday, this is groundbreaking. So I'm very delighted and actually honored to participate in this conference. Now, my paper and the research project behind it is entitled ASEAN Human Rights Law, a concept. Now I'm fluctuating between the concept or an emerging field, but you will see in a moment why am I still shifting between these two titles. Now the aim of this research project is to conceptualize this emerging ASEAN human rights law. Now I'm very delighted to be preceded by the presentation by Karina, because in a way my work is building on this existing literature that makes a lot of analysis about this emerging field of ASEAN human rights law. Now, for the next, let's say 15 minutes, I will talk briefly about the background of this research project, and then I'll summarize the key arguments in the paper that's been circulated. I don't know how exactly it's circulated, but I have submitted the paper. So that's the plan. So let's start with the background. The project really began with a simple observation that ASEAN human rights law as a field is emerging before our eyes. There's something that we can call ASEAN human rights law, and yet it has been rarely fully conceptualized in a way that is, refers to a distinctive field of law. Now, of course, we have lots of literature on ASEAN and human rights, human rights protection in this region, so on and so forth. But most of the work either assess whether the effectiveness of the system or clarifying the law that has been developed or critiques. So we have lots of critiques, right? But what I found from the literature, which seems to be a gap, huge gap, there is this conceptual task, so it's conceptualizing exercise. So that's what I want to do. Now, why I want to do that? Because of the lack of a clear concept, one thing that we can, one problem that we can observe is that this field of ASEAN human rights law has rarely been used or compared analytically with other systems. And a good illustration of this is, if you look at textbooks, many good textbooks on international human rights law, you will see that there's a chapter on regional mechanisms, right? And almost all do not have mechanisms from Asia or Southeast Asia. Obviously, you have, European system, European Convention of Human Rights with European Court. You have Inter-American system with the American Convention and the Inter-American Commission and Courts, as well as the African system of human and people's rights, right? We have that. But most textbooks, especially the ones written by, and all of these are excellent textbooks, do not mention or have a chapter on mechanisms or system in Asia. So for example, if you look at the textbook by Professor Alston that came out this year, excellent, but no Asian system. Another one by Professor Oliver de Schutter, you've seen that as well, no Asian system, right? So my guess is that because there's no clear concept of what ASEAN human rights law is, and that's why it doesn't conjure up in the mind of the people when they write and discuss systems. Now, the aim of this project is to offer a coherently conceptualized account of what ASEAN human rights law is, and I have a couple of research questions. One, how does this ASEAN human rights law as a field look like? What are some of the key characteristics of this field? Then, historically, how has it developed over time? You heard a very thorough historical account already, so I want to address that question from a conceptual perspective. And ultimately, I want to address what should be the future of ASEAN human rights law as a field. Now, as you can imagine already, the contribution of this project is on a conceptual level. It builds a lot on existing literature, but let's say the novelty or the contribution would be a clear conception of what this field is. And I'll just talk quickly about a theoretical framework before I proceed to the paper. So I borrowed and adapted a highly influential work of a French sociologist, Pierre Bourdieu. So he has a very influential and illuminating field theory. And his theory is quite simple, right? So in any social field, not just in law, typically there's a pattern where actors in the field either compete or cooperate with each other so that they gain authority in that field. Now I'm adapting that to describe ASEAN human rights law as a field, and I'll explain that in a moment. Now let's turn to the paper. The paper that has been circulated is very short, it's 3,000 words, that's the word limit, so it's very short and very crude actually. But and also it's an ongoing process, so I'll add more in the full paper. So the paper is divided into two main parts. One is the doctrinal construction of the field to explain what exactly is this ASEAN human rights law from a doctrinal perspective. And the second part is the historical development, right? So let me explain each part in turn. So from the doctrinal construction perspective, that section explained two aspects of ASEAN human rights law as a field. One is a question of sources of human rights norm. The other one is mechanisms, right? So in the sources, with regard to sources of human rights norm in ASEAN human rights law, of course we have treaties going back to the ASEAN Charter. We also have region-specific treaty on trafficking in person, especially women and children. But treaty is not, unlike other systems, is not the main source of norm. I argue in that section that the more potentially significant norm are customary law and soft law instruments. Custom, because if you can prove that it exists, is binding on all 10 or 11 states. If you count East Timor, which is a non-member state, but it's in the region. So if you can prove that there's a regional customary international law regarding human rights protection, is binding everyone, so it's potentially more significant than treaties. But soft law instruments are also important, as you can, as you heard from Carlina, not because it's binding, but because it can be invoked in domestic settings, including courts. So that depends on domestic circumstances as well. So that's the sources and some of the key characteristic, which is, is not really primarily a treaty-based source, but it's other forms of law. Now let me turn to the mechanisms, human rights mechanisms. Now, as you again, I'll keep referring to Carlina. As you heard, we have mechanisms in Southeast Asia in the form of the organs of the ASEAN as an international organization, right? There is AICHA, ASEAN Intergovernmental Commission on Human Rights, but there's also ACWC as well, focusing on women and children's rights. There also is a specific commission on migrants' rights, migrant workers' rights as well. So all of these are organs of ASEAN, the international organizations. Now, the key characteristics of the mechanisms here, first of all of these are political organs, right? So the way they work, the outcome of the organs are political. That's number one. Number two, because it's political organs, the way they work would follow the political branch. So in particular, AICHA, the ASEAN Intergovernmental Commission on Human Rights, the way they adopt resolutions or the way they work, typically they will wait until the ASEAN foreign ministries adopt something on that specific issue, and then they will just follow it, right? Now, there's a significant development on that front, because with regard to Rohingya crisis in Myanmar, it's the first time that the AICHA moved before the political branch. So that may be an outlier, or it may set a precedent. That's something we have to see, right? The other characteristics would be the lack of a court, regional court, or adjudicative body. Now, I do not really, my argument is I don't want to sort of oversell this point, because if you look at the history of the inter-American system or the African system, initially they don't have court. They didn't have courts. So court came later, right? So in a way it's not unique. Now even in Europe, of course you have court from almost day one. But initially, if you look at the history of the court, initially there were strong resistance from some of the major powerful countries, including former empires, because of the whole issue about colonial, the rise of the people in the colonies. So the court, yes, we had court, but the way the European court become very powerful, I think you have to wait until 1970s. That's really when the judges felt more comfortable, felt that it would be difficult for France, for UK to get out of the system. So yes, there's no court, but no, there's no court in Southeast Asia, but that's not unique in a way, historically speaking. So that's the doctrinal part. Now let me turn to the historical development part. The history you heard earlier from Kalina, but what I am doing there again is from conceptual perspective using Bourdieu's field theory, right? So what I found is that when you look at the debates, either on the questions of norms or on questions of mechanisms, you will see a recurring pattern of arguments. Now, what is that recurring pattern of arguments? So typically, you will see that some governments would try to deviate from the UN standards, so to speak. So either the norms that have been developed at the United Nations or a kind of mechanisms, at the UN, right? So some governments will try to deviate from that. So using ASEAN human rights law as a field or as a ground to lower the protection that has been agreed at the UN level. So that's one side, but that's the other side. So some other governments, as well as civil society, NGO actors, would use the same forum to align with the UN. Okay? So that's a typical argument in the contestations over norms and mechanisms that you find. So this part, I'm still trying to do more empirical study, looking at all the documents that come out from different steps that Kalina mentioned, different debates when ASEAN Charter was adopted or was drafted, when the ASEAN Human Rights Declarations were drafted, or when AICHA was set up, when the TOR was drafted. So I looked at all of the debates and the negotiations in this context, and to see how concretely this, alignment versus deviation recur. So that's the historical development part. Now let me quickly finish on the conclusion of the paper, but that will be a third substantive section in the full paper. So looking into the future, how the future should look like for ASEAN human rights law as a social field. Now I take issue with this deviation from UN standard versus alignment with UN standard. Now my argument is that for ASEAN human rights law, the debate shouldn't be like that, or shouldn't be framed that way. My view forward is that ASEAN human rights law should be a field where actors supplement the UN standard, both in terms of norms and the UN mechanisms. There should be no replication with what has been agreed at the UN. Rather, the regional system should supplement the UN, right? So for example, at the moment, AICHA is developing quote-unquote ASEAN Human Rights Index. Now, of course, at the UN or at the global level, there are so many indexes already, including a very thorough and comprehensive index by Office of the High Commissioner for Human Rights. Now, if we do the same thing at ASEAN, it doesn't add much, right? So my argument is that, yes, we should adopt all of this, we should develop all of this, but the point is to add to what hasn't been done at the UN or global level. Now, the crucial point there is a sense of ownership. So through this contestation and cooperation in this field, actors will develop a sense of ownership over human rights norms and mechanisms that have been developed. And that's quite, that will be useful, especially from a legitimacy perspective. So that's the draft, and that's the idea that I have for the full paper, and I'm very looking forward to the comments and questions and the discussion. Thank you.
Thank you very much, Dr. Sengrai, for your presentation, and really on time, on my clock. 15 minutes sharp. Okay, so we know that Dr. Sengrai tried to propose that the so-called discussion and also negotiation on how ASEAN having a human rights, but as part of the ASEAN, maybe we need to double, triple our effort to make such kind of a convention in ASEAN. But I really do support your thinking, and hopefully the member states will serious about that. Okay, thank you very much, Dr. Sankara. And next, we have already Mr. or Mrs. Nivedita Chaudhary and Sri Chaturvedi, which will presenting on the title Upholding the Right to Profess and Practice the Religion of Choice, Comparative Study on the Constitutional Courts in Southeast Asia. Ms. Dr. Nivedita completed her PhD excuse me, from Indian Law Institute in the area of environmental law and human rights. She completed her LLM from National Law School of India University, Bengaluru in human rights law, and LLB by honors from Dr. Ram Manohar Lohia, National Law University, Lucknow. She also holds 1-year postgraduate diploma in urban environmental management and law from National Law University, Delhi and WWF India. She has actively contributed research papers in the areas of environmental law, human rights, constitutional law, and is in the editorial board of various journals. She has previously worked as assistant professor of law at the School of Law, Delhi, Metropolitan Education, affiliated with the GGSIPU, New Delhi, and India International University of Legal Education and Research in Goa, where the co-author Ms. Sri Chaturvedi, excuse me, she has a teaching experience more than 6 years. She has been part of teaching, designing, and implementing the course curriculum of various subjects, notably constitutional law, administrative law, human rights, and environmental law in universities like Jakram Lake City University of Bhopal, National Law Institute University Bhopal, Dharma Shastra National Law University Jabalpur, Rabindranath Tagore University Bhopal, and India International University of Legal Education and Research, Goa. She is presently pursuing her PhD from NLIU Bhopal in an intersection of constitutional law and human rights. She completed her BA LLB by honors from National Law Institute University Bhopal, LLM in Constitutional and Administrative Law from Gujarat National Law University, Gandhinagar, and also has an MA on Sociology. Her readings and publication primarily focus on the areas of constitutional law, sociology, human rights, land acquisition laws, environmental laws, and affirmative action. Dr. Nivedita, the stage is yours.
Thank you so much, sir, and thank you so much for such generous introduction. So we'll start with the presentation. Dr. Nivedita and my co-author, Ms. Srishti Chaturvedi, she is also here with us. So the topic of our presentation is upholding the right to profess and practice the religion of choice, a comparative study of constitutional courts in Southeast Asia. So the paper has been mainly divided into two broad parts, and it is a working paper. We are still working on the paper, so we are going to present a working paper here. So the paper has been broadly divided into two parts. The first, alright. So the first part basically talks about the concept of religious freedom and how well this right to religion has been protected in the Southeast Asian region by the National Constitution and the courts. Given the fact that there is a lack of regional human rights mechanism, as has been presented by my fellow presenter in the earlier presentation also, that there is no regional human rights mechanism available in the Asian region. So we are going to discuss that. And in the second segment, we have actually talked about the constitutional provisions and the landmark judicial decisions which are there, which have dealt with the religious freedom, the right to religion in this in the Southeast Asian region. We have dealt with that. And we have also analyzed the effectiveness of the national constitutional courts in protecting this right to religion in Southeast Asian region. But for this paper, we have limited the scope of our study to only 4 countries, and the 4 countries are Indonesia, the Philippines, Thailand, and Vietnam. We have started with, as I've already told you, that we have started with the conceptualization of right to right to religion and what exactly is religious freedom when we talk about in terms of Southeast Asian religion. So we are going to understand the religious perspective of right to religion. And we have highlighted that the concept of right to religion is a cornerstone of international human rights law, and it has been upheld by various international instruments, including International Bill of Human Rights, which includes Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, and also International Covenant on Economic, Social and Cultural Rights. And there have been a lot of violations of this right to religion, and a lot of instances have been reported from Southeast Asian region only. So this makes this discussion very, very significant and very timely discussion. So that's why we are discussing this. Another reason why we are discussing this is that the Southeast Asian region particularly represents significant cultural and religious diversity, which again is another important reason why we need to discuss religion in the Southeast Asian region. So these are these complexities makes the topic very, very relevant. So dealing with the first part of the paper, wherein we talk about the concept of right to religion, wherein we conceptualize religious freedom. So we have highlighted, the paper has highlighted that right to religion is a multifaceted is multifaceted in nature, and it has varying definitions, and there are different implications of this right to religion for state action as well as for individual practices. The first part of the paper, the first segment of the paper also talks about and also highlights the categories of religious freedoms which are there for state action and the implications relating to it. So the first category is non-interference, wherein the government refrains from interfering in religious affairs. The second category is neutrality and equal treatment approach, wherein the governments, they ensure equal treatment of all religions. And the third approach talks about the minimalistic approach of the government, where the government establish an official religion but must not restrict the rights of minority groups or enforce a particular religion on individuals. So these are the categories that we have discussed, and we have also discussed the horizontal and vertical dimensions of religious freedom. So the findings of this particular segment of the paper is that religious freedom is a complex and multi-layered concept, and the realization of right to religion, it requires balancing all the three categories that we have just mentioned while addressing horizontal coexistence and vertical state fairness. And for region like Southeast Asian region, the challenges lie in managing the diversity which is there, addressing historical conflicts and ensuring inclusivity in the midst of deeply rooted cultural and religious differences which are there within the region. The second segment of the paper, as I've already stated, talks about the constitutional models and the constitutional protections which are offered to this particular right to religion in Southeast Asia region. So for our study, as I have mentioned, that we are restricting ourselves only to the 4 countries. So we have highlighted the constitutional provisions which are there in these four countries. So we have talked about Indonesia, we have talked about Philippines, we have talked about Thailand, and we have talked about Vietnam. And all these 4 countries, they recognize this right to religion in their constitutions, but the interpretations that they have regarding this right to religion and the implementations, how they basically implement this right to religion, it varies significantly from country to country, which is again, the reason could be due to the historical and political context that is there in these countries. Now, when we talk about Indonesia, so Indonesia has particularly recognized this religious freedom, or you can say the right to religion, in Article 29 Clause 2 and Article 28E of the Indonesian Constitution. And Indonesian Constitution recognizes only 6 religions. But this recognition of only 6 religions, it creates challenges for the indigenous and the unrecognized faiths which are there in the country. And it has also been highlighted in the study that minority groups which are there in Indonesia, like Ahmadiyya and Shia Muslims, they face significant persecution and social marginalization in the country. Moving to the Philippines, the Constitution of the Philippines has recognized this right, particularly in Article 3, Section 5 of the Constitution. And in the country, Catholics are in majority population and Muslims are in minority population. So there are conflicts. Conflicts have been reported in both the populations, specifically in Mindanao region of the Philippines. Coming to Thailand, in Thailand, section 31 of the constitution has recognized right to religion, and again, the Thailand community is predominantly they're Buddhist, and the minority groups are Muslims in the southern province, in the southern region of the country, and they also, the Muslim population which is there in Thailand, they also experience discrimination, and there's a lot of conflict due to perceived favoritism towards Buddhism in public policy and law in Thailand. Coming to Vietnam, in Vietnam also, the Constitution of Vietnam recognizes right to religion in Article 24 of the Constitution. And here also in Vietnam, the Buddhist people are in majority and Catholics are in minority. So conflicts have been reported in Vietnam region also. Now, the findings of the study, of this segment has been that these four countries, they constitutionally guarantee and they constitutionally recognize religious freedom. However, the extent and nature of their practice vary significantly. That has been stated in this, and it can also be seen that constitutional guarantees which have been given, they have to coexist, and they coexist with systemic discrimination, persecution of minority groups, or excessive state regulation of religion. So these are the findings of this segment. The last segment of the paper have actually highlighted some of the landmark judgments wherein the role of the constitutional courts have been highlighted, how the constitutional courts have played a significant role in protecting the right to religion of the people in these four countries. So we have highlighted certain judgments. For instance, in Vietnam, we have highlighted this judgment called Vietnam Buddhist Sangha versus Ho Chi Minh City People's Committee. This is a judgment of 2012. And in this judgment, the court has upheld restrictions against the Unified Buddhist Church of Vietnam and reinforced state control over religious practices. In another judgment of 2016, Go Quang Minh versus Hanoi People's Committee, the court ruled that religious organizations, they must operate under government oversight. So we can see that in Vietnam, the court has emphasized the state authority and have suppressed independent religious organizations, which has actually undermined the genuine religious liberty. Now, coming to the Philippines, for Philippines also we have highlighted certain judgments, and the most important judgments are the Estrada versus Sandigan Banyan of 2001, wherein the court underscored the importance of respecting religious convictions within the public sphere. And the second judgment is a judgment of 1989, which is called Salonga versus Cruz. And in this judgment, the court ruled against restrictions based on religious beliefs and affirmed constitutional protections. So it can be seen, as per our discussion in the paper, and we have highlighted that the Philippine Supreme Court has actually actively safeguarded religious freedom, and they emphasized upon the separation of church and state, which has actually fostered an inclusive environment for diverse beliefs within the country. Moving to Thailand, in Thailand we have talked about this one judgment, Wat Phra Namak Gaya of 2017, wherein the Supreme Court has avoided fully contesting state power, and they have emphasized reconciliation between religious freedom and national security, which has actually highlighted that despite the constitutional guarantees which have been given or provided by the Thailand constitution, the Thailand judiciary's deference to the state's promotion of Buddhism has actually led to societal and institutional marginalization of minority community like Muslims and Christians in Thailand. Lastly, in Indonesia also we have highlighted that the Constitutional Court of Indonesia has actually failed to safeguard the religious minorities adequately in the state, and they've legitimized intolerance and marginalization of groups like Ahmadiyya and practitioners of indigenous faiths, which has actually caused a lot of societal turmoil. So with this, so these are certain findings of our paper. We are still working on our paper, so we would like to conclude here that, and we would like to state here that despite the constitutional assurances which have been given by these countries through their constitutions, religious freedom still remains incomplete, and it still faces significant obstacles in the Southeast Asian region. The key challenges that have been highlighted in this study, it includes that there is a lack of judicial independence probably, there is governmental interference in religious practices, there is social intolerance and prejudice. Also, and lastly, there is also a failure on the court's part which to align fully with the international human rights standards. So one of the suggestions that we have at this stage is that the Southeast Asian region, they must embrace a more inclusive governance approach to probably accommodate its religious diversity while protecting individual human rights. So thank you so much for listening to us patiently.
All right. Thank you very much, Dr. Chaudhary. Actually, you still have around 3 minutes, but that's fine. Yeah, your presentation have clear and succinct. As for the right to profess and practice and religion of choice, in which also you touch upon my country's decision on the constitutional court. That's very interesting. Lastly, do we already have Dr. Okay, unfortunately, Professor Balakista Reddy is not present. So we shall quite time for discussion. So I will open the first round of questions. Maybe 3. Anyone? Question or comments? 1, 2, 3. Okay. Yes. Can you please state your name and where you're from?
Okay. Good evening, Mr. Yaman. I would like to ask this question to Mr. Okay. Nice to meet you, Mr. Phil. My name is Mirza. I'm currently a PhD student at the University of Groningen. My dissertation research actually concerns about human rights integration in ASEAN as well. But in this occasion, I would like to emphasize that I might have different opinion than yours, by which, as you stated before, ASEAN has a very unique approach in terms of human rights, by which ASEAN Human Rights Court is something which is, if I may quote what you have said before, still unnecessary in this phase of human rights development in ASEAN, but we should rather develop a concept known as human rights law. I do agree with this concept. We may have further discussion concerning this matter later behind the scene. The thing is, concerning human rights issues all across ASEAN member states, as we know today, the persecution concerning Rohingya ethnic in Myanmar, freedom of the press, for instance, in certain ASEAN member states, and religious minority persecution as well. Don't you think that ASEAN Human Rights Court is actually essential in this particular matter? Because if these human rights cases keep going on and on over the years without any effective legal enforcement, this will create something which we may not expect in the future. We do want, of course, a effective solution from all ASEAN member states. And with our current subsidiary body known as ASEAN Intergovernmental Commission on Human Rights, with its ASEAN way and non-intervention principle, this has proved to be outdated in tackling regional human rights issues. So, could you please
All right.
enlighten us in that regard? Thank you.
Okay. Thank you very much, Mr. Mirza. Christian?
Yes, thank you, Phil, for your presentation. It's great. My name is Christian Schultes, Max-Planck Institute for International Law in Hamburg. My question for Phil is about the AICHR and the Rohingya crisis. So one thing you mentioned was that the AICHR acted before, let's say, ASEAN acted at the political level. Could you give us a few more details? What did the AICHR do exactly? Was it the statement, the report, I don't know, study? Maybe interesting to know. And what were their recommendations, or how did they frame it?
Thank you, Christian. Yes, Mr.
I'm Max Fulham, a third-year law student here at THUS, specialising in public international law. And my question is to you, Carolina Lubies. You mentioned that one of the benefits of the non-binding, non-interference method of ASEAN is that it creates a common legal or a common language and sets standards, bringing all ASEAN member states into the discussion, into the same standards. However, I'd like to ask, is that effective enough in protecting human rights standards in Southeast Asia? Because we've seen, again, in the Myanmar situation with the Rohingya population, that the crisis is still ongoing, and is the systems effective enough? And if not, how can we develop them while still respecting fundamental principles of non-intervention?
Okay, thank you very much. We have 3 questions and comments. 2 for Dr. Sengkurai and 1 for Carlina. Please.
Yes, thank you, Mr. for a question about, let's say, ASEAN Human Rights Court, right? So first of all, just clarify. So when I said I didn't want to oversell, the role of court, what I meant is that, so typically when people refuse to talk about ASEAN human rights law, largely that's because there's no regional court, unlike other regions. And what I was trying to say there is that, well, yes, that's true, but that's not a good reason not to talk about it. Because, inter-American system, African system, initially they have commissions, right? So we still recognize us as an emerging field. So that's the point. Now, specifically about whether we should have a court or not, I think here we can learn a lot from a very good line of literature from political science. For example, there's a good research book, and which is almost an ongoing project by Beth Simmons. So the book is called Mobilizing for Human Rights. And one of her arguments is that all of these human rights mechanisms at the international level, the effectiveness of these mechanisms depend a lot on domestic conditions. The point for international mechanism is to mobilize local actors. So either politicians, obviously NGOs, academics, so on and so forth, right? Now, that means if the domestic system is already very good, democratic, constitutional, robust protection, you don't need international mechanisms. But on the contrary, it also means that even though you have international mechanisms, but if the domestic condition is completely, oppressive, completely authoritarian, so having international mechanism in that sense wouldn't be very effective on the ground as well. So the sweet spot is the semi-authoritarian, semi-open, semi-liberal, which may be, the conditions of some countries in Southeast Asia. So in that kind of, for those countries that have that conditions, maybe regional or international mechanisms such as regional courts may work. So that would be my answer. So yes, we can have this idea and proposal about having a regional court, but we need to discuss further. Is it going to be effective, especially making real changes on the ground? And for countries such as Myanmar, for example, with the whole domestic situations, the crisis, even we can have ICJ. Of course, there's a pending case against Myanmar, right? But to what extent that would translate to real changes on the ground, that's still open for question. So that would be my long-winded answer to your very short, but good question. Thank you. Now on Aisha, yes, I mean I can give you the full detail, but really the point I'm getting at there is that so to my knowledge, is really the initiative of some members of AICHR, so AICH is AICHR, some member within AICHR who are very sympathetic with the Rohingya plight, the plight of Rohingya people. They were really trying to push forward. So it's the first time that we have condemnation from AICHR that came out before foreign ministers meeting. But then, of course, as you heard, we have 5-point consensus. But really, for this topic, they didn't wait until the political branch moved. Yeah, so that would be my short answer.
All right.
Yeah.
Carolina?
Yeah, thank you for the questions. If I understand it correctly, is the ASEAN Human Rights Declaration effective enough to handle human rights issues in the region? That's the question, right? Okay. I can promise you a satisfactory answer because if we discuss about effective, we should discuss about what is the measure indicator of effective in this regard. Particularly in human rights team in Southeast Asia, it is difficult to say which one, which kind of mechanism is the most effective for the region. But I will try to answer like this. ASEAN Human Rights Declarations is the only human rights declaration in this world that take the circumstances into account, the circumstances of Southeast Asia into account, because they put particularities, cultural diversity in the Southeast Asia and transfer it into language of human rights declarations. In that sense, for me, ASEAN Human Rights Declaration is useful enough. I wouldn't say effective, but useful enough to try to create a common term, common vocabulary for human rights in Southeast Asia. But if we consider effective as a decision, as a binding decision come from the court, I will say ASEAN Human Rights Declaration is not effective at all because it's only soft law and it's non-binding in nature. So it will depend on the way we understand the concept of effectiveness in the end of the discussion. I think that will be my answer.
Okay. Okay, thank you very much. But before we continue to our second session of discussion, I was just told that online that Professor Balakista Reddy is joining us with us. Professor Reddy, are you there? Can you turn on your camera and the audio? We are not yet hearing you.
Good afternoon, sir.
Okay.
Just a piece of information. On behalf of Professor V. Balakista Reddy, I, Dr. Attinidi, will be presenting the paper on his behalf.
Okay. Okay. Great. Please, Doctor, on behalf of Professor Reddy, to present the paper on reformulating the international legal order in the wake of COVIDization insights from Southeast Asia. 15 minutes, time is yours.
Thank you, sir. First of all, I would like to thank the organizers, the respected chairs, the respected panelists, for allowing me to present my paper, and a sincere apology to you of informing you in the last minute. So to begin with, if I may be allowed to share my screen.
Yes,
is that
please.
possible?
Yes, please.
I hope it is visible.
Yes, can you make it full screen, please?
Yes, sir. Is it visible now, sir?
Yes, yes, that's fine.
Indeed, sir. Good afternoon to all the panelists. I, Dr. Attinidi, is here to present the paper Re-evaluating the International Legal Order in the Wake of COVIDization, Insights from South Asia. To begin with, the global order is largely influenced by globalization, liberalization, privatization, digitization, and COVIDization. In this paper, I have divided the paper into 4 main parts, primarily dealing with the brief about the international legal order and nexus with respect to the implications in South Asia, the historical underpinnings of the international order. Thereafter, I will be heading towards the COVIDization and South Asian regional perspective, and lastly, I will be dealing with India's role in changing the world order. As I have just now stated, that the global order is primarily influenced by these 5 main factors, that is globalization, liberalization, privatization, digitization, and COVIDization. The concept of COVIDization is analogous to globalization, and it primarily underscores the widespread impact of the COVID-19 pandemic and the varied responses by the governments, private bodies, and the individuals. Now, over the past 4 years, the pandemic has universally affected every country, not only the country, but the industries, humans in varying degrees. Now, this particular phenomenon have called for an examination to see the critical impacts with respect to the international legal order in South Asia. As the pandemic have raised certain fundamental questions about the impact of the future pandemics and the role of international legal order, it also have diverted the shift from a bipolar to a multipolar world and the prospects of the international cooperation among various nations. In South Asia, primarily, if you see, the pandemic too has acted as a catalyst for introspection and the reform to be taken within the national and the regional legal setups in relation to the reevaluating the legal order. From healthcare inequalities to the economic downturns and governance in the various nations, the region has experienced the need for more resilient and inclusive legal structures. So in this paper, I will be specifically investigating whether the existing legal framework has failed to address the role of the international legal order, primarily the international organizations and the other institutions which has been specifically set up in order to propose the pathways for building a resilient global system across the nations. Now, coming up with respect to the historical context of the international legal order, in order to understand the efficacy of the COVID-19 towards the international legal order, we first have to see why there is a need to have a developed legal system in that particular sphere. Now, historically, if we will see, the international legal framework had favored developed nations primarily, leaving the developing countries which also includes South Asia and other marginalized countries. Now, because of this setup, after the Second World War II, the international legal order was largely shaped by the newly formed United Nations and the Bretton Woods Conference. Now, these two particular institutions, they have promoted for the international cooperation and economic stability. But while these institutions have been framed, they also suffered from the various criticism at a larger scale, which ranges from the inherent power imbalances between the nations. They indeed stop the major crisis and strived to promote multilateral political and economic cooperations between the sovereign nations. So these frameworks which has been set up as a result of the Second World War, they fell short of addressing the main issues with respect to these countries, be it the global health crisis, be it with respect to the recent COVID-19 pandemic, be it in relation to any such human rights perspective, global governance, etc. Now, as we all know that recently the world has faced an unprecedented pandemic, right? Which was, and tackling with that particular pandemic was very difficult, because the developing countries they faced the brunt of it, and as they have struggled to access the essential medicines and vaccines, the gaps between the developed and developing countries have widened, and it has raised the serious concerns regarding the effectiveness and the fairness of the current international legal order that is in picture. Now, the challenges that is exposed by the pandemic, primarily the COVID-19 pandemic, we all know that it has disrupted the established international legal framework across multiple domains, right? That is including human rights, including public health, including trade, security, and whatnot, right? So there are several challenges that has been exposed by the pandemic in nexus with the international legal order, that is with respect to the global health governance failures, inequities in vaccine distributions, rationale for reevaluating the international legal orders are some of the concerns or are some of the challenges which the international legal order has to primarily address. Now, coming up with respect to the COVID-19 and the nexus and its connection with respect to the international. Now, as we move ahead, now we have seen the gaps that this particular recent pandemic has led in the sequence for the future countries, right? Now, coming up with respect to the international legal order, coming with respect to the COVID-19 pandemic and the international law. Now, if you will see with respect to the implications that the COVID-19 had put upon on the developing countries, primarily, it has been divided into various domains, right? First, with respect to the disruption of international legal orders. Now, in relation to the disruptions of the international legal orders, now this COVID-19, they have created tensions between the developing nations and the other countries, that is the sovereign nations, in relation to have a collective global action on this particular issue. Second is the global cooperation and tensions. Now, while the pandemic have underscored the necessity of international cooperation, but it has also brought various challenges into the upfront. That is, the various countries, though they have prioritized their perspective with respect to the various issues, be it trade restrictions, travel bans, vaccine nationalism, but it has led to the prioritization of the national over international interest. Each countries were left to their own selves in order to work upon or in order to conduct their activities. Second, lastly is the emergence of the emergency powers. Now, as the pandemic spread, many states, they invoked emergency powers, significantly altering the legal landscape of their nations. Now, these powers, what these powers did, they allowed the government to bypass a certain legal process, and which led to, in a way, it led to the conflict between the international human rights law and the governance norms at the global level. Moving ahead with respect to the key challenges with respect to the COVID-19 and South India perspective. Now, in relation to the key impact of such challenges that we have witnessed or that we have seen just now, there are other challenges that occurred as a result of COVID-19 The first is the healthcare inequality, second, economic downturns, and third is the weak governance system. Now, as we move ahead, we are talking about the nexus with respect to the COVIDization and the international legal order. Now, one of the challenges that has been severely seen during the COVID-19 pandemic is the uneven healthcare infrastructure. Now, as we all know, that South Asia is a home to over 1.8 billion people and has one of the world's most diverse diverse system, yet it is inadequate or inequitable when it comes to the healthcare system. Because countries like India, Bangladesh, Pakistan, they faced severe strain on the healthcare resources during the pandemic, which not only highlighted the disparity with respect to the nations, but also highlighted the access to the healthcare services in these countries. Secondly is with respect to the economic downturns. Now the pandemic caused unprecedented economic disruptions across South Asia with significant GDP contractions that was reported in the year 2022. And it also included a series of the reasons with respect to the economic downturns which ultimately affected the South Asia drastically. Lastly is the weak governance system. Now, governance as a concept is one of the major realm under the international law. Governance weakness, such as with respect to whether it be bureaucratic delays, corruption, lack of coordination between the nations, or it has resulted in the resistance against one nation towards the other nation. Lastly, coming up with respect to specifically on the India's role in changing the world order. Now, under the India's role, the challenges has been divided into 4 aspects with respect to the vaccine diplomacy. Second, advocating global health equity, challenges to the global health governance, and lastly, with the human rights and governance issues. Now, in short, I will be just structuring with respect to the India's role. Now, the concept of vaccine diplomacy, which emerged as a strategic tool towards the COVID-19 pandemic, it has with India and China at the forefront, it has played a very crucial role in the international legal order. Now, if we will see that India, as India played a crucial role as a major supplier of vaccine globally, but there were various hindrances to the same, because according to by advocating the temporary temporary suspension of the intellectual property rights, India reinforced its commitment to the equitable distribution of vaccines across the nations, but still faced various challenges under the Indian upfronts. These challenges can be seen with respect to the structural flaws in the global health governance, which India faced. Secondly, was with respect to the profit-driven R&D models that overshadowed the public health priorities in relation to the public funding mechanisms. That was the second aspect, and lastly was in relation to the human rights and the governance issues.
I'm sorry,
Now,
Doctor.
with respect to the
Yes. All right. Thank you.
Just to conclude, according to this particular paper, the author is primarily trying to implicate in its finding that the COVID-19 pandemic, though, has served a powerful catalyst for re-examining the international legal order and reshaping the power dynamics worldwide. But in the 21st century, there has been various transformative changes that has disrupted the status with respect to the major players in South Asia in terms of technology, health, sustainable development, human rights issues, and in relation to the efficacy of implementing the true international legal order at the global level. Thank you.
Thank you very much. Okay, now I would like to open the second round of question, comments, or anything from the participants. Anyone? Okay. Yes. Before participant will ask any question further, I have a question for Dr. Didi, yeah, regarding this so-called disruption of the international legal order. Do you think that how can a region such as Southeast Asia, as a specific region, be in a role to contribute to reshaping the international legal order? Can you give us a specific sector that might the case for that one? Dr.
Indeed, sir.
Yeah.
Yes, I'm here only.
Yeah.
With respect to the specific sector, in order to highlight the disruption of the international legal order, with the international legal order as with respect to the COVID-19 pandemic, the sector that can be can improve upon in relation to the in relation to the set pattern, it could be with respect to the healthcare sector primarily. Because if we will see in relation to the championing of the global health equity, the health sector is considered as one of the sector in which the regions, in which the commitment with respect to the individuals, the the vulnerability sections and the other peoples, they are at stake. So, in order to reform the international legal order, the healthcare sector and not only the laws with respect to protecting the rights of the people should be protected in an efficient manner.
Okay. All right. Thank you very much, Dr. Didi, for your explanation. As for Dr. Sengkurai, do you think that the ASEAN Forum still be a relevant place to start what is so-called rule-based negotiation for so-called ASEAN human rights law? What do you think?
Yes, yes. I'm just trying to think of some examples. But let me start from a sort of a normative kind of analysis, right? So for me, I think the sense of these are the norms and mechanisms and institutions that we built with our own hands without any sort of imposition or interference from outside. I think that sense of norm ownership is very important, especially from the perspective of participatory legitimacy, which may lead to compliance with the rule as well. Now, in that sense, this forum, where governments and ideally non-state actors can participate, debate, discuss, persuade, and build something together that will become, components of ASEAN human rights law, is important in that sense. It's important in that sense, participatory legitimacy sense, which will lead to the sense of norm ownership, and it will sort of is almost a tool to tackle this criticism that we hear, at least from the 1990s, about debates about Asian value debates, right? We don't want Western countries. I mean, this is governments. We don't want Western countries to tell and teach us, lecture us about what should be the norms about human rights, so on and so forth. So, if we can limit that discussion to the region, where governments in the region as well as non-state actors can participate meaningfully, so I think that's important in that sense.
Just follow up on that one. We have so-called the core of International Human Rights Treaty,
yes,
right?
Yes.
And I think all of the ASEAN member states, some have signed
Yes.
Those treaties. So, if we have this so-called
UN core human rights.
I mean, if we are already in the same treaty, why do we need another ASEAN human rights?
Great. So that's the last point that I was sort of, throwing in the room, right? So yes, we have 9 United Nations core human rights treaties. The ratification rate is very uneven. Thailand has accepted 8 out of 9. 1 is in the process, but 9 is migrant workers. So for Thailand, it's only the issue of migrant workers that is politically very sensitive, not likely to become a party soon. But for other countries, Cambodia, Vietnam, the ratification rate is very low. So first of all, even though we have UN core human rights treaties, they are not binding on every state sort of equally. So that's number 1. Number 2, and this is the argument that I'm trying to develop further, is that great, we have UN system, and the human rights issue in Southeast Asia can be addressed in that forum, in Geneva, so to speak. In Geneva, Human Rights Council, Universal Periodic Review that was mentioned earlier, and the whole periodic reports under each human rights treaty. So that's fine. Now, the point of ASEAN human rights law as a distinct social field or field of law would be to complement that. So, in terms of norm, for example, in the ASEAN Declaration on Human Rights, there's a right to, let's say, safe and sustainable environment, which is not there or clearly not there in the covenant. Arguably is in the International Covenant on Economic, Social and Cultural Rights, but it's not clear yet, right? But that's in the ASEAN Declaration 2012. So ASEAN can complement the UN in that sense. So that's on a normative level. On the institutional level, for example, that can complement that too. The role of AC, what's the acronym of that again? Women at the ACWC that help governments to prepare reports for the UPR process. So that's another example how the regional mechanism can supplement the UN system. And there shouldn't, as you rightly sort of imply in your question, there shouldn't be replication, and that should be avoided.
Okay.
Yeah.
All right. Thank you, Dr. Singkurai. My last question to Carolina. When you're talking about ASEAN Way, the heart of ASEAN Way is non-interference. Yeah. And how can you offer this so-called promotion and protection based on non-interference in the way that political solution has been always on the table?
Okay, thank you for the intriguing questions. Well, the non-interference, if we see, there is hope about ASEAN Way, particularly the non-interference, because the non-interference is slightly changing toward a flexibility. I will give three events to underline the movement toward the flexibility. First, when ASEAN postponed the membership of Cambodia, but I forget the year. Postponed the membership of Cambodia. ASEAN as an association postponed the membership due to the internal affairs of Cambodia. The second example is when ASEAN as international organizations blocked the participation of Myanmar in the ASEAN summit due to the internal affair of the country. Lastly is the way of national member states individually the way the Asian Intergovernmental Commission of Human Rights now already receive complaint from ASEAN citizens due to the internal affair in the territory of ASEAN member states. So non-interference now is slightly changing to the flexibility, because when it comes to the human rights violations, the non-interference is, yes, you can interfere, slightly change toward that direction. So that is why I said there is hope in this principle, because it is not that rigid as it was before. Maybe that's
All
my
right.
answer.
All right. Thank you very much, Ms. Karina. Again, I offer one last round. Yes, Mirza. Yes.
Okay. My question is actually for both Bill and Carolina. I think this is still relates to ASEAN Way. According to your explanation, in a very legal sense, how possible is the redefinition of ASEAN Way along with its non-intervention principle? Because as a matter of fact, ASEAN's rigid approach in terms of human rights, with its consensus system by which all states must agree upon for certain regional issues including human rights, well, this is actually the thing that hinders us in creating or developing our human rights integration even further, even as far as establishing ASEAN's Human Rights Court. So, how do you view this phenomenon?
This. Yeah, both of you. Yes.
Thank you for being the first person to answer.
Okay.
Okay. How the ASEAN Way evolved to support human rights in the legal sense? Okay. I will use the work of Eminent Persons Group to answer, to give recommendation. Actually, I will use their work when they create their report. Back then, when they were assigned to start the drafting the ASEAN Charter, they already discussed about the possibility to make the non-interference flexible for human rights violations. The second stance is they already discussed the possibility to use voting as a complementary mechanism for decision making. So they already start the movement, the initiative. Our task now, as current legal scholar, is to reopen the discussion using the international organization law framework. Because now ASEAN already established itself as international organization, use the line of reporting regulation, line of reporting. For example, like the ASEAN Human Rights Body, they can follow up or report to the ASEAN Foreign Minister to discuss again about the changes or redefinition about the sensitive issue, less sensitive issue. Because if this alter, we can this can be the opportunity for us to say, so let us apply vote other than only consensus, or let us give enforcement power to the ASEAN Human Rights Body. So that will be a possible recommendation to try to make the legal sense become more powerful in ASEAN Human Rights Body. I learned from the history.
Yeah. Great. So I suppose you're interested in sort of legal analysis, right? So let's start with sort of general international law, or the law at the United Nations Charter level. So the principle there is non-intervention, and that has been interpreted to mean that the prohibition of coercive action. So, for example, in the Nicaragua case before the ICJ, 1986, that's exactly what the court said. Even though we have the word, or even though we see or we have the principle of non-intervention, what exactly is prohibited is coercive action of one state against other states in the areas where that latter state can decide freely, right? So from that perspective, and this is a well-established view, so from that perspective, as long as there's no coercive action against other states, that doesn't trigger non-intervention principle. So that's start from there. Now, zooming in, Southeast Asia or ASEAN, right? The way non-intervention or non-interference have been interpreted in a way is different from that general international law that I just explained. It goes beyond non-coercive action or prohibition of coercive action, right? Because the way governments interpret non-interference or non-intervention in Southeast Asia is almost that you cannot criticize, you cannot condemn what's going on domestically, right? So in a way, you can argue this is lex specialis, limited to Southeast Asia. You can argue, possibly, that this is regional customary international law, right? Now, again, from a legal perspective, and I think Karina is absolutely on point here. Now, if we say that there's this lex specialis that we see in ASEAN Charter or is regional customary international law, then you need to see subsequent state practice of the 10 or 11 states. And if you look at them closely enough, you will see that there's some inconsistency in the application of the law. On some topics, some issues, governments feel that they can criticize or condemn what's going on in the country. So you can try to analyze, concretely in what context this principle has been interpreted, liberally or flexibly. For example, I think the Rohingya crisis that has been mentioned earlier is a good example here, especially in the context where you have domestic situations that create transboundary consequences, such as the Rohingya crisis, where you have, exodus, refugees, or the ongoing, oppression of government in Myanmar that creates refugees, civilians sort of get out of the country, going to Thailand in particular. So that's no longer domestic affairs because it creates transboundary consequences, let's say, right? So I think in those contexts, it's easy to argue that even though you criticize or condemn government actions, that doesn't violate non-intervention and non-interference.
Okay, thank you very much, Dr. Phil, Carlina, and Dr. Nidhi, Dr. I forgot the name, Dr. Nidhi and Chaudhary and Dr. Sri Charufedi for the presentation. Unfortunately, we almost ran out of the time, but your presentations are well regarded in this panel. And please have a round of applause for this panel. And I hope these papers will be soon published in a journal somewhere, so we can read the full versions of the papers. Thank you very much. I'll see you next time. Thank you.
Thank you, sir.
Thank you.